Now, there's been an important Supreme Court decision in the case of Harper Trust and Brazel. Paul Chamberlain is the head of employment law here at JMW Solicitors. So, Paul, what has been decided by the Supreme Court?
Dominic, wow. Yes, it's been a very interesting few days. So we have been anticipating this decision for a while. The case was heard at the back end of last year, but we didn't actually think we'd get the decision until much later. It is quite an interesting decision. It's extremely complicated. So we'll do what we can to try and distill it in this short presentation. It's to do with holidays, and it's to do with the calculation of holiday pay for those who don't work full time or work irregular hours. Now, the principle broadly so far applies to employees on a permanent contract, but where they have irregular or infrequent hours. And the lady in this case was actually a music teacher engaged by a school. She worked during term time, and then of course she had the usual school holidays off, but her contract was a what we call an overarching contract. It covered the whole year. And the school decided to calculate her holiday pay on one basis, and then changed the basis on which it paid her holiday pay. It calculated her holiday pay by reference to a 12.07% calculation of what she'd earned each term. So it looked at the earnings in term one. She then took the holidays, and then what it paid her for the holidays was 12.07% of what she'd earned in the previous term per week. Now, that is a very prevalent way of calculating leave or payment for leave, where someone has got irregular hours or doesn't work for the full year. The Court of Appeal decided that it was wrong, and the Supreme Court has looked at it on appeal from the school and has agreed. Now, there will be lots of ordinary employment situations where this is extremely relevant, but a lot of people know that we work in the recruitment sector, and we have a lot of employment agency and employment business clients, and we work for a lot of umbrella companies. Now, those who are in that sector will very, very easily recognize that 12.07% calculation. And to cut an extremely long story short, the use of that percentage moving forwards now is going to be almost impossible. Instead, what the Supreme Court has said is that you must, first of all, give someone who works those irregular hours their full 5.6 weeks entitlement to paid leave under the working time regulations. And what you must do to calculate their pay for that leave is look back over the previous 52 weeks to average out what a week's pay is. And in most cases, not all, but in most cases, we think, as does the Supreme Court, that when you do that calculation, you'll be paying them more than 12.07% of what they were earning previously. So there's some maths involved, but the 52-week averaging calculation is likely in most cases to give rise to an increased entitlement. So there'll be some changes moving forwards for those who use that system. You may have heard, as indeed may some listeners, that a lot of people roll up holiday pay, certainly in the employment business and umbrella sector. For every hour that you get an additional sum, which is designed to compensate you in advance for your holidays. So you don't get any extra pay when you take the holidays. The argument is you've already had it. And that calculation is done at 12.07%. That is going to be problematic, very problematic moving forwards, which means it's going to be difficult for people in that sector to properly calculate or accurately calculate people's entitlements to leave, and practically quite difficult for the end user clients. So if you send a temp in, the client that the temp is going to work for them to know with any certainty how much they're on the hook for with the agency when it comes to paid leave. So it's a big decision.
So, Paul, what are you telling the clients who are contacting you and looking for advice on this?
Well, I think what we're now saying is it's very much a bespoke calculation for each employee. I should make the point that the Supreme Court decision, at least as you read it, only applies to employees. There are lots of workers in the employment business and umbrella sector who are not employees. They are engaged on what are called contracts for services. So there's a question mark over whether they are caught by this decision. But even if they're not, the ramifications of it are extremely wide. So bespoke calculations, that's the first big change. If the contracts have a specific mechanism outlined in them for calculating holiday pay, that needs to be revisited and the contracts might need to be amended. And that can create a lot of administrative and rather burdensome work for most employers. But the other thing to bear in mind, Dominic, is that there are likely to be some claims because, of course, whilst this isn't a sort of retrospective decision, what it says is that if you're calculating holiday pay by reference to the 12.07% mechanism, which you shouldn't have been, then under the Employment Rights Act, you can claim back 2 years' worth of effectively unlawful deductions if you think you've been underpaid. So we think there are going to be a lot of claims from individual employees affected by this, which could stretch back 2 years, probably not any longer than that in most cases, but could stretch back 2 years. And that's going to be difficult for certain organisations in certain sectors.
Sounds like a real headache, a real minefield for HR directors and for the agencies that you mentioned as well. How can you and the employment team at JMW help, Paul?
Yeah, I think that's right. It is a headache. And I think the thing to do is, because it's such a complex decision, is not to have a knee-jerk response to it. I think they need to be very carefully thought through decisions taken to make sure the proper response is made. So we will be advising individual clients. Obviously, we'll be providing some general guidance with blogs, bulletins, webinars and seminars. But if anybody thinks that they are impacted by this decision, then please do call or email, and we'll take them by the hand very carefully through it.